All right, here we go. We should be in the building. Good morning, y'all. How is everybody doing? Hopefully y'all are doing well. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats at ClassEbeats.com. And y'all know what's going on today. We've got day 2. This is day 2, the official day 2 of Judge Whitaker being on the YSL trial. We got a lot of crazy things that are going to go down today. A lot of motions that we're going to hear about, specifically 2 that we're very interested in here. We're going to hear about Judge Whitaker deciding whether Love and Hilton are going to stay on the trial. We're also going to hear back about a couple other things as well. Definitely going to find this interesting. We might have a mistrial today. That's one of the motions that she's allegedly going to rule on today. So we're going to get into it here shortly. Looks like the courtroom is still getting ready. I see a couple people are still filing in. So I'm going to bring everything up on the screen and we'll get ready for it. I know Judge Whitaker is getting comfortable in there already, being a little bit late today. She was late coming back from break. Struggling this morning, but how's everybody doing? Let me know how y'all are feeling in here. I know we got a couple other people that are doing live streams this morning too, so I want to shout them out. I honestly wasn't even gonna do this live stream, and I almost changed my mind about 5 minutes ago because I saw TLA is going live here shortly. I wish I could tune into that live stream because, again, I always give him his props. He is a true professional when it comes to these legal matters. But y'all go check him out. We've got Kat Nutt Williams is going to be live streaming this morning, as well as infamous Sylvia, I believe. But I appreciate y'all being here. Thank you for joining the show. If you could, make sure you like the video on your way in, and we're going to get into it here shortly. Now, let me double check and make sure they haven't started yet, because I'm trying to keep us on a little bit of a delay. Yep, here we go. We're getting into it right away.
Productive evening.
Good morning, y'all.
And I understand that the parties have a proposal with regard to at least a portion of Mr. Copeland's testimony. Sorry, I didn't have this turned on. So what I said was I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony. So
give me 1 second.
Hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening,
we know who you are.
and Mr. Schardt had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals, and we can move forward from there, Your Honor.
All right.
So basically they need more time.
I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well, so we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround, so we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos.
There's 8,000 jail calls too.
Probably do that now.
Crazy.
Y'all think? Otherwise, give me something else we can do this morning.
Can we talk about whether Love and Hilton are going to stay on?
We can do that. If you can, we just need that.
That's what we want to know.
We just need to get that material very quickly to the office. I mean, to the courtroom. But we can do that.
All right. Send somebody to go do that, please. And I'm, has anybody thought through yet? And maybe
Yeah, they switched seats.
we'll have ready soon any kind of
Plea.
potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony. Well, I guess generally Mr. Copeland's testimony. And then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
They know
Your
what's
Honor,
happening.
given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor,
Here we go, Brian.
I would, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on.
Ooh, Brian
That's
is
what I'd
out
like
for
to do.
blood,
All right,
man.
well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
Wow.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I will get the exact language that I'm speaking of.
All right, great. Thank you. I appreciate that.
They already know,
Okay.
but he wants it on the record, I guess.
Anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Schardt, and I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this, by next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday.
Dang.
So that needs
Judge
to
Whitaker's
accelerate.
falling through.
Okay, we will work on
ready to get
accelerating
started.
that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well if their thought was next Wednesday. I mean, like, I'm thinking this Friday, okay? Which is the day after tomorrow.
Coming up
All
quick.
right, with regard to...
Y'all like the video on your way in.
And you're talking about the videos of his testimony, right? Or are you talking about...
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
the giant list of...
the giant list of exhibits.
Yeah, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters.
Yeah, sure,
for that. I
and
thought you meant Mr. Copeland's testimony.
No,
Okay,
Your Honor.
all right. My misunderstanding then. Okay. All right, so with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using, or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions. Some of the redactions we did concede on. So once I get that list, I can let the
Well, I've already seen those with regard to a
audio's
couple of
so
things,
bad.
but I haven't gone through.
Too.
I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things, but what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this, and we're okay with that ruling?
We believe
That's
out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be 2 that we think may need to be re-argued.
Okay.
I just want to, we don't think there's many, at least from the state's perspective.
All right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that
not
occurred
again.
on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, just so that we're clear for the record purposes.
Are you
This
serious?
is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful. Yes.
Okay.
We were made aware,
That's
leading
crazy.
to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred.
And then there was another
We
one.
found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. At no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there
Wow.
after finding out about one ex parte meeting and having to drag the truth out. We sat
Crazy.
there, and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th.
This is crazy.
What
yo.
happened in that meeting on June 7th?
Oh my God.
The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the
Throw
judge
it
said
out.
in this ex parte meeting,
Throw
yes,
this
I've
whole thing
observed
out.
these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele. And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense.
Wow.
And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. and I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele.
Wow.
This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting.
It's absolutely disgusting. I agree. Well said by Max. And we're going to start here in a second, but to see even more so that not only was Brian Steele right, Glanville was on the prosecution's team, but you have Judge Krause saying that Glanville did nothing wrong, everything was fine and above board. And now we're hearing about another ex parte meeting that took place. This is just they got to throw this whole thing out.
There's a lot more discussion.
I have zero faith in this.
But the bottom line is,
Fulton
if you
County
ask
justice system.
me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on at trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those
let
rulings?
him cook, Judge Whitaker.
Absolutely,
this is crazy.
We need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay.
Let that man cook.
It's not okay. It's offensive. And it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night. Nothing about this is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects.
I haven't seen the transcript yet, y'all, so I don't know.
Once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised.
We don't need to do all that.
Considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that.
Yeah, no kidding.
And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what
Come
y'all
on,
are
Judge Whitaker,
talking
this is
about,
crazy.
Doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward, in a calm and professional manner. Okay.
And I think the thing with Judge Whitaker is she's making it very clear and has made it very clear that she is going to go through the process. She's going to go through the steps. So I know a lot of people out there were hoping for a mistrial today. I'm not seeing that happening, to be honest, because if she's talking the way she's talking right now and saying, okay, once we get to the part of this trial where you guys ask for a new case, a new trial, then we'll address it there. But right now we got to get through all these motions and keep it moving.
So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections, responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level a assertion that Mr. Schardt is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Okay, well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case.
There you go,
I would be
Whitaker.
a little hot under the collar as well.
See, she's fair. We got to give it up to Judge Whitaker. She is very, very fair. She's saying, now, Miss Love, stop playing. You know what you said. And first look at the transcripts are going to show that y'all were saying some reckless stuff about the other side. So don't sit here and act like the victim, like you didn't do anything wrong. And if they had said these things about you, you'd be feeling some type of way as well. Good for Judge Whitaker. She's fair. She's fair.
Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that.
She said everybody can get that smoke.
The reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Jeez.
Yes, sir.
If I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance
we got
to
to see
look
if we
at
can
it,
find
but
that.
that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because, again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation.
Yeah, no kidding.
I, like Mr. Schardt, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't
get
there.
her, Weinstein.
We don't have a video of it, so I have no idea specifically if that was not referred to us. And we don't know, do we? We don't know. And what I do know is that What I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot. So I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say,
they're cooking Glanville this morning.
Filed it, and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. Yeah, if y'all feel like you need to get it off your chest, come on.
Here comes Brian Steele.
Now's the time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor. I
mean, I don't either.
Okay.
I don't either.
Man,
I already
even
said
Thug is
I
laughing.
understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right, well, you know.
Glanville, where you at, man?
What do I say?
I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, you know, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet.
What?
I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers
Weinstein is about
trying
to
to
pop
herd
off.
cats. And that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on
it's about a fair trial, Judge,
and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean,
You're
all
right.
right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides.
This is amazing. I cannot believe this is real.
I will look at the two transcripts and I will make a ruling And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Yeah, these motions are about to start flying in. And Judge Whitaker is about to be flooded with motions. We've got Max. We've got Weinstein said he already filed one. We've got Young Thug is going to have to file one. We'll see what Mr. Harvey does, but this is just, I haven't seen the transcript, so I'm not going to overreact like them. But if what they're saying is true, it's just another point against the prosecution, because they just did this over and over and over and over and over. And Brian Steele was even saying they're going to be able to show a pattern of how they've done this in the past. Or I'm sorry, Max Schardt said that, how they've done this in the past as well.
All
Disgusting, man.
Anybody else, or can we move on to evidence?
How do you get justice
Mr. Steele.
when the state is behaving this way?
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection, because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put it in at all. So I understand what you're doing. You know, okay, we're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said. Yes, I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Schardt had actually put that particular objection in writing in one of your filings anyway. Essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but...
I had one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So there's like two layers of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on actually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
Yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Schardt, Mr. Steele?
Yes, Your Honor.
Yeah, so that's what I would like for y'all to address.
And he was also told that he could lie.
I believe based on two positions, OCGA 246621, which be impeachment by contradiction, as well as a prior inconsistent statement, in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and 24, the 24-6, 621's the
Impeachment.
by contradiction, and 24-6, 613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's
Yeah, welcome to
evidence,
Fulton County, Judge
y'all
Whitaker.
had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead.
Y'all, this is wild. And while they're trying to figure that out, let me see if I could pull up this motion for mistrial.
We can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
Yeah, let me skip forward a little bit.
Knowledge. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
I believe. If your court thinks that's good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Miss Love and or Miss Hilton perceived and therefore caused them
I'm not sure why they subpoenaed him.
Speak to the court ex parte or not, don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
Yeah, that's a good question. I don't know why they subpoenaed him. We'll see.
He will go through the emails for the court that were misrepresented by Lawyer Love. He will I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that.
Mm-hmm.
That he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland.
She did.
To Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place, because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree that.
I knew he was going to bring this back up too.
Ruling, and she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a Honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland were not, is he literally counsel for Mr. Copeland right now. I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, "Oh, you seem to want to talk to him, so I will let y'all talk privately," which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interests, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland. It was, is he really acting in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat-out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight, because Georgia law, and I gave you these cases in a footnote, Georgia law right now, and I know I'm very familiar with this Honorable Court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding, it's over. The case, no one looks at prejudice. But the two cases that came out,
he had a right to
in
be
April. One of them had been in January, but I cited them in the footnote of my motion to just educate the court.
Well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong.
Okay.
And we need to show prejudice.
Okay. With regard to,
like federal.
Give me the cases and what.
Step back.
Okay.
But so I want to make a record of showing it was prejudicial because there were knowing misrepresentations to even have a auspices of a meeting with the judge.
Okay, well.
And I'm not agreeing.
I'm not sure if I follow you, though, with regard to, I need to establish that Mr. Melnick was, in fact, counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick, because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's I can take judicial notice of that to the extent I need to.
Please do.
I mean, articulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton and Love, are not true. There's no emails to back up what Love
Get him
says.
out of there.
Ms. Hilton, there is not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press. I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, as a fair tribunal.
Right.
That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate.
That's right, boss.
So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand, and I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday the 10th? Okay. So let me make that determination.
I'd like to call him if you change your ruling. Both of them, Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this. I want to get it right.
All right, so you haven't talked to him yet about what? All right, well, obviously I'll give you a chance to talk to him before you make a proffer, because you need the proffer to be accurate.
Okay.
All right, so that's not something we can do right now either.
Okay. Thank you.
All right.
All right, here we go.
So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday, and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay. Thank you. All right, let's come back at 11.
Wow, are we for real breaking for an hour and a half? Oh, man.
Does the court mind that we stay here?
Doesn't matter to me.
We're breaking for an hour and a half? Dang, I hope not. Hold on, let's skip forward and see if they come back.
Deputies, so if that's fine, that's fine. But I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay.
Okay, so it looks like we might have a huge comfort break because the defense doesn't have their shit together. This is insane. Wow. Yeah, I'm going to skip ahead. Looks like, nope. So it looks like, y'all, we're going to be on break for a minute. So while we do that, we're going to do this live in real time. Let me see if I can go through and find this motion that was filed by Yak Gotti, aka Doug Weinstein. So I've got the first page of it here and we can kind of look through it and see. Let me see what y'all are saying in the chat though. Shout out to everybody who's in here. If y'all could, make sure you like the video while you're here. We've got 413,000 people in the building. Dang. Appreciate y'all being here. So what we're going to do is I'm going to find this. Let me see what y'all are saying in the chat. Bobby T showing some love, says, ClassE, forgive me for asking, but did you go to law school? No, I wish I had, man. Seems like you have more knowledge than the average person here. I'm not that knowledgeable. I've been, as I mentioned in my reply to your comment, I've been studying and following law just for the past few years, and I've been following this case really closely. So I've learned a lot from TLA, from the lead attorney, from a couple of the people in the YouTube space that have been, that are legal professionals and been covering this case. And you pick up a lot of things and see a lot of patterns as we're reviewing motions, as we're going through some of the responses. So I think y'all should really take the time and do a lot of this for yourself too. I usually leave a link to some of the pages and some of the videos that have helped me to learn and grow. But I will say following the lead attorney anytime he's covering a case like this is been so helpful for me, just because I've learned so much, and he makes it easy to retain and understand the information too. So shout out to you. Yeah, I didn't realize we were gonna have this much of a break. Lauren Robinson said, dang, I wasn't trying to actually do work today. Now I got you. We've got some more stuff we can look at here in a second. Sky Mosaic says, I understand what you're saying. Woody is a hostile witness and nobody has revealed totally what was said in the meeting. Yeah, it's disgusting, man. We can't believe anything right now. At this point, it should be a mistrial. I'm with Sky Mosaic on that. And it's just frustrating, you know, because I think, and people were asking me in the comments of some of these videos, they said, whose side are you on? I'm not, right now, I'm not on anybody's side. Right now, I just want to see things go fairly. And the prosecution has given us no choice. We're not blind. We're not stupid. We have common sense. But to call them on the carpet and say, what y'all have done is wrong. What Judge Glanville did was wrong. You lied to the sworn witness. You had several ex parte meetings, which we're going to talk about in a second. You gave him false information, met with them without him. I mean, there's just so many things that they've done. And some of them arguably are against the law and definitely against the Georgia Code of Judicial Conduct, which we're going to cover in a second. But man, this is crazy. Mar says, I'm a part-time college professor. My biggest pet peeve is students showing up unprepared. The state seems like they've never been to law school. Why aren't they prepared? No, I have no idea. And you can tell and see that Judge Whitaker is getting irritated. She said, all right, well, if y'all just want to take time and prepare and use this as study hall because you weren't ready to go, then I guess I'll just go back in chambers and review this transcript. So what I'm hoping is going to happen, I'm hoping the first thing she does when she gets back there is she tries to get a copy of this new June 7th ex parte meeting we're hearing about. She reviews it because, as y'all saw at the beginning of this live stream, at the beginning of trial, Weinstein and Max Schardt were heated. They were pissed about what was said in those transcripts. So I'm going to see if we could find it here. I know, shout out to Joseph Papp. It looks like he might have the initial one. Yeah, here we go. So we're going to get to see exactly what Mr. Weinstein is saying in this motion. So let me go ahead and pull this up for y'all and we'll cover it. Let me read a couple more comments and then we'll get into it. All right, let's see. So we've got the motion here. I'm going to slide this over so y'all can see. Boom. Got it right there. And shout out to Joseph Papp for making this available as well. He's been doing a great job covering this trial too. Let's see. BP Bo says, you're doing a great job. Appreciate you, BP Bo. Thanks for stopping by. Make sure y'all like the video too. Bobby T says, right is right and wrong is wrong. Ain't no side but that. Very well said, my friend. Very well said. Jazzy J says, I know for a fact that Fulton County courts are prejudiced against black defendants. Yeah, I mean, Jazzy J, that doesn't surprise me. And I mean, let's be real. Fulton County is full of black folks. So however you slice or dice it, you're going to see a lot more black folks coming through that system than you probably would white people. So it sounds like you have some experience there. You don't have to speak on it if you don't want to, but if you'd like to call in and share your experience with the Fulton County court system, please feel free to do that. If y'all want to call in too, while we've got, I was going to say a little bit of a break. We got a lot of a break. While we have a big break here, y'all can call in. The link to call in is in the description as well as in the pinned comment in the chat. Boss says this case is too big. That's why they aren't prepared. It's like high school versus the NFL. Mars says exactly, boss. This is a RICO trial. Yeah, I don't know what Fanny's doing, but she needs to rein this thing in. She's gonna have to intervene at some point. Sky Mosaic says nobody seems to care if he's guilty or not, but if you talk with people in the Cleveland Avenue, crime has fallen. Yeah, I care if he's guilty, but we've been distracted by the gross misuse of power by Judge Glanville, Love, and Hilton. We were moving fine up until this point. We were laughing about Lil Woody on the sand, saying he's crazy. I publicly called him a snitch, which, I mean, let's keep it real. A lot of this doesn't happen if he doesn't talk to the police. So I think we hold people accountable as we go along the way. But man, this is a huge distraction from the bigger issue. Is are these RICO charges factual? Do they have foundation? Will they be able to move forward? And the prosecution did this to themselves, because I don't know. Say it's a mistrial with prejudice or what have you. I mean, say the case gets dismissed, or say we retry this with all the content that's out there. With I'm covering it, TLA's covering it, Cat Not Williams is covering it. You've got Infamous Sylvia is covering. You've got Kayla Bumpus herself and Little Woody speaking out about this entire trial. And you're going to tell me that we have a mistrial and we're going to try and redo this. We're going to try and redo this case. And every single person that lives in Fulton County hasn't seen or heard how the Fulton County court system is working. No jury. I'm telling you right now, no jury is going to look at this and say, okay, well, maybe Thug did it. No, all they're going to remember is she fired. All they're going to remember is Judge Glanville got kicked out. They're going to go back and watch, excuse me. They're going to go back and watch our YouTube videos and be like, dang, they were acting like that. These are for jury members that haven't even been selected yet. So when it comes to whether Young Thug is guilty or not, if this case does not move forward, there is no way a Fulton County jury is going to find Young Thug guilty after this. There's no way. Mar says, if black people do the crime, they have to be prosecuted. Stop with the race card. Yeah, I don't like playing the race card, but y'all can do it if you want to. It's fine. BP Bo says, first time, is he from the Caribbean? Who, me? I do understand you very clearly. Do you have a Caribbean connection? No, I don't. But shout out to all my Caribbean brethren over there. Boss says, Love went from acting like a judge boss under Glanville to a timid lawyer under Whitaker. And y'all saw Whitaker, she does not have a problem snapping back either. She said, okay, Love, listen, I get what you're saying. And you're trying to take some shots at the defense, which again goes to the characters. It just adds more weight to the characterization that the defense is trying to show when it comes to Love. She took every chance that she could get to say, oh yeah, tell them, Judge, they're being disrespectful to you. And Judge Whitaker said, okay, well, in their defense, you don't need to talk, because if what I saw in this transcript is true, then you messed up big time. Excuse me, y'all. Lauren Robinson said they're all going to remember for sure. You cannot forget all these viral moments that we've had from this trial. You can't forget it. And everybody is watching this trial. I had someone tell me that they called in or they came up on video to the live stream, and somebody in another state, Tennessee, somebody in Tennessee said, hey, I was looking up videos on what was going on with the YSL trial, and I saw you were up there. And I'm a smaller channel. people are watching. Everybody is watching this. So the prosecution, aka Fannie Willis, better hope that this trial goes down the way it's supposed to go down, or the way she wants it to go down. Because if not, I don't see them winning this at any point. All right, let's go ahead and get into it, y'all. This is going to be a fun one. This was actually just filed this morning, right before everything started. This is a supplement to motion for mistrial by Doug Weinstein, aka DeMonte Kendrick, aka Yak Gotti. And the reason this was filed, because as we just found out during the court proceedings, that there was another ex parte meeting that took place on June 7th. I don't know what the prosecution's doing. I don't know why they thought they could get away with this, but as I'm sure Mr. Weinstein is going to say, they forced his hand in this instance. He was giving them a huge benefit of the doubt and said that he feels like a fool for doing that. So let's see what he's saying here in this supplement to Yak Gotti's motion for mistrial. Comes now, Yak Gotti, by and through his undersigned counsel, and brings the supplement to motion for mistrial, showing as follows. Outside agitator in a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whether it is by definition an outsider, Professor Dylan Pendergroth, UC Berkeley. Judge Glanville making outrageous allegations against members of the defense team in this present case. But I think it does in some way outside agitators and everybody else who I think are trying to influence. The third ground argued in Kendrick's motion for mistrial is that Yak Gotti's due process rights were violated, relating to the 14th Amendment due process violation, relating in part to Chief Judge Glanville wrongly coercing Little Woody to testify. Further evidence of the state and Judge Glanville's violation of Yak Gotti's due process rights has come to light. He's referring to the June 7th ex parte meeting. Yesterday after court, Yak Gotti received a rough transcript, Exhibit A. So we've got the transcript here, y'all. Oh man. Of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th, 2024. And this was the day, if you remember and go back, that Little Woody received his use immunity. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers, except for Yak Gotti's counsel for the last 19 months. Basically, he's saying that everyone out here on YouTube was trying to tell y'all that Judge Glanville was messed up, and he gave him the benefit of the doubt. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. So if y'all can't tell, Weinstein was pissed off in court. And now you can see it here in his motion, because he's using a lot of language that Brian Steele was using when he filed his multiple motions as well, saying that Judge Glanville was acting as a member of the prosecution team. So he's done holding back, and I'm sure he'll be on either a podcast or an X Spaces or another interview talking about this very thing. And Doug Weinstein, if you want to come up to the channel, feel free to do that at any time. Yak Gotti's counsel takes no pleasure in alerting this honorable court to this situation, but client obligations require it. Due process requires a fair trial. It is not a fair trial when in an ex parte meeting, Judge Glanville, Love, and Hilton gossip like, yet, what is that? What is that word? Yentas? I don't know. I don't even know what that means. Over 13 pages of transcript about attorneys Schardt, Melnick, and Steele. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Lil Woody. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton attacked attorney Kayla Bumpus for allegedly hugging Yet Gotti and stating that she is incapable of representing Copeland. Yentas is what y'all are saying? Okay. I've never heard that term. Oh man, I'm sure Kayla wasn't happy about this. It is not a fair trial when in an ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. I'll be interested to see how Kayla responds to this, because she was walking the thin line when it came to Glanville, Love, and Hilton. She was saying, hey, I've got clients that I got to represent in Fulton County. I'm not really going to speak out against them, but now they're taking shots at Kayla. I'm sure she was not happy about this. So we'll have to see if she's responded to this yet, for sure. It is not a fair trial when in an ex parte meeting, Glanville starts talking about outside agitators, stating, my comments today were predicated on there's a lot of stuff that's going on in the background, and I shouldn't have to do anything with you all's case. It really shouldn't. It shouldn't have anything to do with y'all's case. It really shouldn't. But I think it does in some way. Outside agitators. It is not a fair trial when in an ex parte meeting, Glanville and Love have the following outrageous conversation. Judge Glanville. But I think it does in some way. Outside agitators. Miss Love. That too. Judge Glanville and everybody else who I think are trying to influence. Miss Love. That is absolutely happening. And this is the rough transcript, page 11 through 12. It is not a fair trial when Glanville, Love, and Hilton have this further discussion. Hilton, there's a lot going on. Love, there is a presence. Yes. That's all. That is all I'll say. Judge Glanville, I mean, but I see it from just being in the courtroom and tracking. Oh. Man. This is bad. How many violations of Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? This case is like an old house that represents honorable judge and is tasked with renovating. Hold on a second. This case is like an old house that the present honorable judge is tasked with renovating. Excuse me. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. No Herculean effort by the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared and retrial barred due to the prosecutorial and judicial misconduct that has goaded Yak Gotti into the present motion. I told y'all, Doug Weinstein's trying to keep things straightforward. He thinks he can win this case, and I think he will as well. He's saying, I didn't want to do this. Y'all are making and forcing me to do this. Wherefore, Kendrick respectfully continues his request that this honorable court declare a mistrial based on at least due process violations of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia. This, the 31st day of July 2024, Doug Weinstein, aka Yak Gotti, aka Mr. Kendrick. So y'all have to let me know what you think about this one. We're going to go on to read and cover and see what's going on with this roughed transcript, as they call it. So we'll review that in another video, but it's going to be interesting to see what happens moving forward, because if what they're saying and what they're alleging in this is true, it's going to be just another major blow to the prosecution. And I don't see how Love and Hilton can stay on this. I'm just not seeing it, because they've made so many missteps, done so many things out of line. And as we even heard Judge Whitaker say herself to Miss Love, when I say that I want everybody in this courtroom to behave accordingly and to behave professionally, I'm not just talking about the defense. I'm talking about you. And we've seen here, I don't even know if it's possible, which again, it makes you wonder, is this the first time? Is this because they've just been continuing to get away with this and get away with this? And now that the light's being shown on this dark area of the Fulton County justice system, you guys let me know what you think in the comments. And let's see what y'all are saying in the chat too. We're going to get to Exhibit A, which is this rough transcript. I cannot wait. This is crazy. And I think I saw, oh yeah, here we go. The amazing Amy is in the building this morning. She said, good morning, Lauren. Oh, she's talking to Lauren. She says, I'm sitting in the doctor's for my yearly checkup. Hey, let's go. I should not have put that on the screen. My bad, Amy. Definitely prayers go out to you. Hopefully everything is good. We know you take care of yourself, so I know you'll be fine. We got Roro in the building. Good to see you. Mar says, Whitaker doesn't play games. She's a career criminal defense attorney. She's low key on the defense side. Just playing it, laugh out loud. He said, just playing it cool. I think she is. She's seen everything that's going down. She knows that the defense is going to need some help here. And this Fulton County system is just disgusting. Absolutely disgusting. Boss says the hearing is full of clips for you later. Oh, you know what time it is. Y'all know we're going to have this clipped up. And Boss said the preacher at church is even talking about this trial as examples of pride and corruption. The preacher at Big Bethel? What preacher are you talking about? Lauren Robinson says it's a Jewish word for people who like to gossip. Yentas. I figured it was Jewish, but I did not want to be racist and assume it was a Jewish word. But I left it alone. Shout out to Amy in the building. Y'all, prayers up for Amy. She's at the doctor's today. Mars says Doug Weinstein is the lawyer y'all think Steele is. Uh-oh. I mean, they're both are good, but Weinstein is smart AF. Yeah, Weinstein, he knows he picks his spots. He knows how to pick his spots. You know, Brian Steele, he's the bruiser. He just comes out there swinging and he's going to knock you down by full force. But I agree that Weinstein is definitely an elite chess player. We got Mr. Tesla up in here saying good morning. Good to see you, man. Mar says we love our healthy kitties. Hey, yo. Jeez. Good Lord. He's not wrong, I guess. Boss said it's like the refs secretly meeting with the coaching staff of one team at halftime discussing what flags to throw during the game. Excellent analogy. Excellent analogy. Boss also says the preacher I mentioned is at my church and is talking about this trial. Oh, that's wild, boss. Yeah, that's crazy. Lauren Robinson said, ooh, they lied on Melnick. Yeah, we're going to get into it in a second. Y'all ready to read this transcript, which I need to update the title of this video too. But let me see. I'll change it in a second. It's not that big of a deal. All right, let's get into this transcript. So as you may have heard, it looks like there was another one ex parte meeting with Judge Glanville, Hilton, Love, and who else knows? We're going to get into it and read the transcript coming up here in a second. I don't know what we're going to hear, but if what Doug Weinstein, Yak Gotti's representation says is true, it's not going to be pretty. Here we go. This is at 2:45 p.m. I'm assuming it's going to be on June 7th, which was the day that Lil Woody testified. Now, again, this is a rough transcript, so y'all have to bear with me. We'll get the official transcript probably here in the next day or so. Check this out. Miss Love, Judge, the reason that we wanted to blank, the reason that I specifically wanted to talk with you is that I have concern about the representation being made of the representation of Lil Woody. I'm concerned and I'm sort of not blank. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or members of the state any legitimate concern that he is regarding Lil Woody testifying.
Stop the cap.
Didn't Mr. Melnick say that he was going to plead the fifth? Oh, man. What we have seen is physical interactions with persons beyond blank besides Lil Woody that would indicate that Lil Woody is not Mr. Melnick's primary priority. Dang! Oh, come on, man. What we do know is that when he blank, I mean the fact that he's willing and wanting to leave and blank leave, number one, he left twice after the court ordered him to speak with his client. And it would seem his actions convey that it is not Lil Woody's best interest that is his priority. Terrible. Miss Hilton was speaking out, was out speaking with Lil Woody at Lil Woody's request at the time that I announced that Miss Hilton was calling Lil Woody. What I did not know is that she was trying to tell you to give us a minute because Lil Woody was feverishly blank, and I will let her speak as to how that went down blank. Feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us. But I thought they also said they didn't know Melnick was representing him. What was that, Miss Hilton, says Judge Glanville. So let me blank. Or maybe it's a pause. I don't know. Let me just put the order of operation. I got up because Deputy Chief Long said he wants to talk to you. Come out right now. So when I went into the room, Melnick either came in or came outside. And what Lil Woody said, and I think that he wanted to get some autonomy. I want to talk to you. He's like, I've already talked to you, but I want to talk to her. And Mr. Melnick kept like blocking him being able to talk to me. Yeah, I wonder why. So eventually I was like, well, clearly you want to talk to him. So I'll step out and you can come in. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. So by the time I got back in there and he started to talk, that is when everyone said, come on, the judge is waiting. And that's why he stormed in angry. Miss Love says, he being Lil Woody, because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation because Lil Woody and I have been having really good conversations since Friday, like very, very good conversations. Just not even about the facts of the case, but just life experiences. So I think I was building a rapport with him such that he thought I lied to him. So I was trying to explain to him, well, you did lie several times. And by that, she means today. Today about what was going to happen, says Miss Hilton. Miss Love says, because of what Mr. Blank, someone conveyed to him blank. Miss Hilton says, we believe that something was being conveyed. What happened is Lil Woody was walking back into the courtroom. Mr. Melnick, blank, and Julie would have to, Mrs. Lindquist would have to confirm this blank, but he said they're going to hammer you. And that made me ask Miss Love, did you say something about hammering him?
Hey, yo.
And I didn't know who to something. Nobody did. Or who to ask is what she probably said. And then Judge Glanville said, it doesn't make sense. You would say that to him. And Miss Love says, we never said that. Judge Glanville. But anyways, okay. Miss Hilton said, so whatever the communication was, that's when he stormed in and got angry. And the result I got was he gave when we started. The result I got was what he gave when we started. So at this point, I'm very confused. Miss Love says he, meaning Lil Woody, stormed in and got angry. Okay. Miss Hilton says the timing of everything is very ironic. We laid it out on the record earlier about what happened, and I don't believe that Lil Woody's best interest is being served at this moment, given that blank. I mean, Mr. Melnick was willing to take vacation and let him languish in jail, and that is not blank. We have communicated that we never wanted Lil Woody to go to jail. Well, here's the thing, though. Lil Woody was there on his own. He didn't have to plead the fifth. Nobody forced him to plead the fifth. What is his lawyer going to do? Lil Woody could have gotten out any time, and Judge Glanville told him that. All you have to do is say that you're going to testify. Now, Melnick did not leave him without representation. When he was going to be able to deal with his contempt, Kayla Bumpus was there. So I don't know. I don't see how they could characterize him as not having Lil Woody's interest. He said, don't testify. Here's what's going to happen. Lil Woody said, I plead the fifth. Judge Glanville said, okay, well, we got to throw you in jail for the weekend. What else was Melnick supposed to do? We don't want him in custody. We don't want any of that to occur. And so blank, Miss Love says, and Mr. Melnick has not spoken. He has not relayed what we did get during the break was an email from Mr. Melnick. I don't know if he had to leave, been blind copying someone else. The only two people I could see on the email were Miss Hilton and myself, but he referred to me as in third person and said, these are communications between myself and Miss Love. So I asked Mr. Melnick, whose interest are you concerned about, your clients or Mr. Steele's and Mr. Schart's? And this is when Mr. Melnick said, you can go fuck yourself if you think I don't have my client's best interest in mind. And then Miss Love says, because prior to blank, and this is not the first time Lil Woody has said he doesn't represent me. Well, we've never heard him say that. This is not the first time Mr. Melnick has blank, and let me be real clear. When he spoke of what was happening before him representing Lil Woody and he told me that he didn't represent Lil Woody. He told me, Judge Glanville says, Mr. Melnick told you? Miss Love says, yes, Mr. Melnick told me previously that he wasn't representing him. Judge Glanville says, you would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated, that somebody was represented by counsel, you would go ahead and let them contact that lawyer.
Stop the cap.
Nope. Miss Hilton said, or Lil Woody would have said, because I know as a witness, because he's not charged, if he would have to blank. And Miss Love says, right. Miss Hilton says blank because he's not charged. Judge Glanville, I don't think you have to because there's no pending charges. But if he told you I got a lawyer, I don't want to talk to you. And Miss Love says we would have left. And then Judge Glanville says, because people counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present. Ms. Hilton says, we have done that with a number of our witnesses, here. So this would have been no different. Exactly. And we have blank. I'm sorry. I don't mean to cut you off. No. Says Miss Hilton. Go ahead. That was it. Miss Love says, we actually communicate, especially either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they have pled guilty here. We only reach out to them through their attorney because we want the attorney to speak to them and for that to be blank, because that's the best way, in our opinion, to get a rapport that elicits truthful testimony. But they knew this is not true because they knew Lil Woody was represented by Melnick and they still contacted him anyway. Crazy. So in this particular instance, there was not blank that, number one, there was not that communication made by Lil Woody that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. Okay, but you're taking away his right to plead the fifth. That's pretty important. Ms. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking to him about, the statute of limitations has run. He didn't do the murder. We know that. Yes, but he asked Ms. Hilton in the June 10th ex parte meeting if he could confess to other things and be okay. She's like, oh, you can say whatever you want to. He said, what about murder and nuts? She said, oh, well, hey, hold on now. Let's not get crazy. I mean, so I don't want to get into the facts of anything. What I'm trying to get at is the fact that Little Woody, I don't believe, has blank. I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. I believe that in conveying to the court that Miss Bumpus is going to stand in his stead, Miss Bumpus has been blank. She has to be blank. She was blank. What's the word I'm looking for? Okay, so I guess these are pauses. These aren't blanks. So I'll use them as pauses. Miss Bumpus has been, what's the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. What are you trying to say, Miss Love? Uh-oh. Miss Hilton says, no, she hugged Yak Gotti. Miss Love says, I'm sorry. Oh, this is getting messy. Miss Hilton says, in fact, she hugged Yak Gotti and hugged Young Thug, and that's how Captain Keatle saw her. And Captain Keatle had her taken out. Miss Love said she expressed dismay and concern in challenging her right to interact in that manner with the defendants. So our concern is not that Little Woody's best interests that are being represented. Okay. Our concern is that it is not Little Woody's best interests that are being represented. And that not only is that the case with respect to Little Woody, who we have no interest in prosecuting, but there is a tampering of sorts going on in this person inserting himself where Little Woody has been reaching out to speak to Miss Hilton, and that communication is being blocked by someone. Little Woody didn't reach out to. You notice no one said, Little Woody called me. He never said, when we put on the record, when Miss Hilton said, the way I understand it, Mr. Melnick reached out to Little Woody because the first time Little Woody paused, the first time we heard an assertion like, oh, he's going to plead the fifth is when Mr. Melnick sent an email to Miss Hilton and myself and had copied on it Brian Steele, Max Schardt last night. The court, or Judge Glanville, says, why would he have done that given, and Miss Hilton says, and that's the state's concern. Miss Love says, that's the point. Judge Glanville says, but here is the challenge. The challenge is you have privileged communications, and unless you've got him being the client, disclosing to a third party that wouldn't be subject to privilege, that is the only way you are going to. I don't disagree with that at all, says Miss Love. I don't disagree with that at all. But if Melnick, and the thing that's got me the most is Mr. Melnick is not looking at Lil Woody saying, you know, Lil Woody, I want you to stay out of jail and I will be here with you. And if you ask anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. He sent Kayla, though. What he did was he looked over at two people and said, like, I did what I could. shrugged his shoulders, held his palms, held the palms of his hands like this as to say, I'm tired. Dang. You can't say that about him, man. There's no reason he would be looking to the right to counsel for the defense like I tried after Lil Woody said he was going to testify. That doesn't make sense. Judge Glanville says, well, there's a lot of innuendo that they have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process. And that's what, pause. Ms. Love says, my concern is Melnick's insertion of himself. But that was his client. Judge Glanville says, what are you asking me to do? What are you asking me to do? And what do you think that I can do? Ms. Love says, that is the exercise. That is the homework for tonight. I wanted to let the court know that this is what we're looking into right now because there is a remedy because I have faith in our law. I love this thing. And I know there is a remedy because this can never have been the first time this happens. It has been addressed. I just have to find it. Okay, so her whole thing is Melnick was working with Brian Steele, and she's saying that when Lil Woody got up there to testify, he tried to convince Lil Woody not to testify. And when Lil Woody said, yeah, I'm going to testify, Melnick looked over at the defense and said, hey guys, I'm sorry. I tried to tell him not to get on the stand. So now Ms. Love is saying that he was looking out for the defense's best interest and not Lil Woody's. And her argument is that if Lil Woody, because he had use immunity, did not testify, he was going to be sitting in jail. And by Melnick convincing him not to testify and to stay in jail, that's not in Lil Woody's best interest. I mean, ooh, it's a lot, y'all. I get it. It's a lot, but that's kind of a summary of basically what she's saying here. Y'all have to let me know if you think she has a point there. I'm not seeing it personally because Lil Woody's already done so much, man. Just sit your butt in jail and do your time, man. Do your time, do what you got to do, wait until the trial is over and say, hey, at least I never got on the stand and I'm not going to, because it's not looking good for any of them. But I didn't want to be looking for something and not let the court know what I'm looking for. So you are not caught off guard when Monday morning or Saturday night or Saturday afternoon, we find it and send it to you. Judge Glanville says, okay. So thank you for allowing us. And Ms. Love says, so thank you for allowing us to audience with the court. I just wanted to make certain that we did it properly and we had everything on the record. It is our witness. We have conveyed to him that he is shielded from prosecution from anything that he talks about on the stand and any use of that.
Stop the cap.
It's not true. And the thing is that we won't ask him. And the thing is that we won't ask him that. But this is what he said. Y'all might not, but they might ask me about some things that I have to assert my right on. And that would be a question by question basis. She said Lil Woody said that. What he is being influenced to do, we believe, by Mr. Melnick is, and it's through Mr. Melnick, because as you saw, Lil Woody said, I will testify. Mr. Melnick, even after that said, he's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Lil Woody's freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, I am here with you. If there is something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail. I disagree. I mean, nobody wants to go to jail, but him getting on the stand and going through this whole process, is that really any better? Y'all tell me. Instead, you get little Woody. Instead, you get little Woody, and you can see through his body language. He gets there in court and he's smiling as if making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say he don't want to be in jail? Miss Hilton said that's his biggest fear. Miss Love says that's his biggest fear, and he's in jail after Melnick asserted himself in this process. But he's his attorney. So we have to figure it out. So when she says Melnick asserted himself in this process, I'm assuming she's talking about him trying to help out the defense is what she means, not by him just asserting himself in the process as his representation. He says, she says, so we have to figure it out. I'm not just laying it on your lap, saying, go fix this. I'm just bringing this to the court's attention. Hold on, let me move this over so y'all can see. I'm just bringing it to this court's attention. This is a grave concern. Miss Hilton, she's about to lose her mind because their biggest concern is that Mr. Melnick is actively harming a human being, and that's what she's maddest about. I'm mad because it is stopping our trial, and it is wrong, and it's wrong. And that is not how the law is supposed to work. So we have two big old grave concerns that we are working to remedy right now. Judge Glanville says, okay, well, like I said, I think that you brought your concerns to me. You know, without more, I don't know. Without more, I don't know what else I can kind of do in terms of that. My comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have anything to do with you all's case. It really shouldn't. But I think it does in some way. Outside agitators. Uh-oh, they didn't like that. Miss Love says that too. And Judge Glanville says, and everybody else who I think are trying to influence. Miss Love says that is absolutely happening. Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes. That is all I'll say. Judge Glanville, I mean, but I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. Yeah, Judge Glanville should have left this out. He's trying to be all buddy with the prosecution. And like I said, since we know he's going to potentially invoke, we'll see what his pleasure is. And Miss Love says, I mean, just the idea of someone sitting in jail throughout this trial. But if that's what he's being counseled to do, and that's what he does, that's just wrong. Is it? It's wrong because a member of the bar is, in my mind, creating that circumstance, you know? No, it's wrong because y'all want Lil Woody to testify. I don't see how that's wrong. He's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about. Sheesh. And can't just sit there and when he sees the train coming, stand up and say, stop. But he's got a vacation to go on, so he can't be there. Oh my gosh. And here we go. They're talking about Kayla now. So Miss Bumpus is going to be there. Miss Bumpus hugging Yak Gotti and Young Thug is going to be here representing the interests of young Woody, who is supposed to testify against Yak Gotti and Mr. William. I mean, shout out to Kayla, but she has a point. And we talked about this in other videos too. Kayla being the godmother of someone who is close to Young Thug. She mentioned Kayla coming in there and allegedly giving Yak Gotti and Young Thug a hug. And now she's representing a witness for the prosecution. They got a point. Anyway, that is where we are. That doesn't pass the smell test. Kayla is not going to be happy about this. I'm telling y'all right now, if she hasn't responded to this already, she's going to have something to say about this. Because, again, with Doug Weinstein saying earlier, he gave Judge Glanville the benefit of the doubt. He wanted to keep things professional, not take it personal. He knows Judge Glanville was in a tough position. He was trying the best to do his job. He even said most recently in an interview that we covered that, okay, yeah, I think Judge Glanville, he's trying to do his best. But man, now you got them going at Kayla, throwing shots at Kayla, who after all this time said, hey, I want to keep it professional. I know I'm going to have clients in Fulton County that I'm going to have to represent. I have to work on a regular basis with Miss Love, Miss Hilton, some other people in Fulton County. So I'm not going to say anything. Now, I think the gloves are about to be off because this is crazy. Y'all saw how Weinstein was acting. And again, I said, I know Kayla is not going to back down from this one. She said that is, and this is, again, this is Miss Love. So she said, so Miss Bumpus is going to be there. Miss Bumpus hugging Yak Gotti and Young Thug is going to be there representing the interests of Little Woody, who is supposed to be testifying or is supposed to testify against Yak Gotti and Young Thug. That is where we are. That doesn't pass the smell test. Good Lord. Judge Glanville says, all right, okay. Miss Love says, thank you. And that's it. All right, man. What do y'all think? This is wild. This trial has not disappointed at all. I'm going to be interested to see what Kayla has to say about this because they were definitely implying a lot in this situation. And when it comes to her professionally, I mean, this just what they're saying is a big deal. I know y'all may not see it as someone who's not an attorney, but as an attorney, them saying this is going to be a big deal. And it could possibly affect her professionally. So I want to hear what she has to say about this. Y'all let me know in the comments. What are your thoughts and concerns about this whole new ex parte meeting that took place? Was this one right? Was this one above board? I don't know. We'll see. I want to see what the comments are saying, y'all. Y'all been hanging in there. Shout out to everybody who's in the building. We got over 600,000 people in here. Let me check and make sure that we're not live. Are we back in court yet? Nope, they're still breaking. So we still, I don't want to go back that far. Let's see. Be on a little 2-minute delay. So we're still waiting for court to get back in session. We probably got another 30 minutes or so. With that 30 minutes, I may go digging and see if Kayla responded to what they said, because that is, woo. If I were her, I would be mad at this. Y'all saw Weinstein was upset already. I know Kayla is not happy about this. Shout out to the new timer. We've got Goner Dang. It says, Ms. Love can't believe she no longer runs the courtroom. Yeah, she's upset. Who else we got in here? I said what's up to Mr. Tesla. Boss says, why hasn't this full transcript? Why hasn't this a full transcript prepared already? Why don't we have the full transcript? I don't know. More secrets being covered up. I wouldn't be surprised. Boss says, does the transcript say the time this ex parte was held at? I think it was 2:45. We go up. 2:45 p.m. And from what I understand, this was on June 7th. So this was after Lil Woody was locked up. What does Amy say? Amy says, doctor came in and I said, oh, let me turn this off. And he said, is this about the YSL trial? And he said, yes. He said, oh, keep it on. I've been following this case. Oh man, shout out to Doc. Salute to Amy. Amy's putting everybody onto the YouTube channel, y'all. We got the doctor. We got the OBGYN listening. That's what I'm talking about, Amy. And this is what I mentioned to y'all earlier. Everybody is following this case. There is no way they can retry this case without the jury showing up on day one and looking at the prosecution like, yeah, I know about you. I know what Lil Woody said about you. You're that one that stinks. Shout out to Amy, though, for putting the doctor on game. Shout out to the OBGYNs out there. We love y'all. Shout out to Lady Bliss is back in here, says mistrial. Lauren Robinson says this is absolutely wild. Boss. Uh-oh, Kayla hugging too many defendants. All right, Kayla, let me, if y'all want to call in, the link to call in is in the description and also in the in the pinned comment in the chat. I need to get Kayla up here. Let me see. Is she live right now? Y'all bear with me a second. I'm gonna go see if she responded to what was said. And two, I'm gonna see if I can get her up here. So we got Lead is live. We got Infamous Sylvia is live. Is Cat still live? Cat is still live as well. I gotta get Kayla up here. I know she is hot. Shout out to Nay. Hopefully I'm saying your name right. Says Kayla was live earlier. Something happened with her in court. She was heated and let it slip who the one it was who told her about the meeting. Let's see if we can find Kayla's reaction. She's not live right now either. I think she's in court. I know a lot of y'all Kayla fans are watching the show. Could somebody reach out to Kayla and tell her and see if she'll call in? She's going live tonight. Y'all said she was live earlier today. She must have been live on IG because I don't see her live. I see her live from last night, but did she talk about this? Probably not. Hold on, let me see if I can find her. I'm gonna see if I can get her to call in. Y'all bear with me a second. Let me see if I could find her. Hold on. Let me see. I'm gonna try and call her and see if she'll answer. Let me see if she answers, y'all. Oh, is Instagram muted? It's muted. She might be down there about to fight somebody. Shout out to Lauren says, my 72-year-old mom is following. Oh, that's dope. She might even be going live right now. Dang, she didn't answer. All right, I might try her again later. Woo, what do y'all think about this, man? Boss says they still on their get your it's together break. Yeah, they're still on their study hour break. Hold on. Audio call ended. Okay, I'm not gonna harass her. I'm gonna leave it at one phone call, and I'll see if she calls me back. This is crazy. Lauren says she's about to be throwing blows. Yeah, you don't want to. For them to insinuate what they're insinuating about her is crazy. I mean, I get there being a possible conflict of interest, but y'all see what they said. Look at this. They said, so Miss Bumpus is going to be here. Miss Bumpus hugging Yak Gotti and Young Thug is going to be here representing the interests of Lil Woody. What? Who's supposed to testify against Yak Gotti and Young Thug? That is where we are. That doesn't pass the smell test. I would be pissed. All right, let me see. So we still got probably about 20 minutes before we're going to get back into it. There's a couple more things I wanted to go over with y'all. We had some other things that happened yesterday too. Let me see if I could find. Let me see if I could find this. Hold on. Because we had another motion that was filed yesterday. We got this one. Okay, what I'm going to do is Cypress Wisteria says they all hug out each other. Yeah. I mean, they're reaching there. Let me message Kayla real quick. So let's just. All right, here we go. All right, we'll see if she calls back. So I'm going to try and find one more thing before we get back into court. Y'all give me 1 second. I'm going to put up the be right back screen. I'm going to play some music for y'all and we'll be back here in just a second. Yeah, they're saying they all hung out together. Yeah, they did.
Say, my brother, my sister, just believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
Since everything starts with self, let me hold this mirror up and take a look at myself. Before I judge you, I gotta check myself. And I come to find out that that's good for my health, right? Change your mind and watch the whole body follow. So you won't hear me talking about I'm hitting you with hollows. I can't do it. Got plans for tomorrow. And I ain't trying to bring my seeds no type of sorrow.
So there were a couple of motions that we didn't get to that I wanted to cover for y'all. Oh, okay. Cypress Wisteria said they all hung out together. Yeah, I messed that up. But you're right. They did. I mean, she's Young Thug's relatives godmother. So we got that one. Where's the other one that we didn't see? State's response to state's motion combined. Response in opposition to Stillwell, compel. Trying to find the right one. Let me see if Thugger Daily has it. Yeah, and that ex parte transcript is going to be major. I'm sure Judge Whitaker is thinking right now, like, man, what was I thinking? This whole thing is a mess. Let's see. So I'm trying to see if I can find this one on Thugger Daily. And we're getting close, y'all, to being back. We got about 20 minutes before we get back into court. But for some reason, I can't find this other motion. Let me see here. Attorneys for filed a response to the state's motion for a mistrial. I think we already reviewed this one. I wanted to read this article for y'all from the Atlanta Journal, but for some reason it's trying to make us subscribe to it. So we'll get it here in a second. What do y'all think so far, though? And I was hoping some of y'all would want to call in. Again, if you want to call in, the link is in the description. If y'all want to call in, let me make sure everything is set up there. It should be good. Y'all should be able to hear it. I haven't heard any word back from Kayla yet. She might be down there right now about to storm the castle. And I was going to actually go down there today. I decided against it because it would just be easier to get the live stream and the full experience here. But I appreciate y'all hanging out with us. Let me see. So we are going to go to what is Thugger Daily saying over here? Oh, we got Mariah the scientist was in the building. I always say her name wrong. We got Young Thug's bond denied. There we go. We're going to get it, y'all. So while we're waiting, we have a couple of these clips we can go through too from Thugger Daily, because a lot of these were so well placed. So y'all check this out. And again, if you haven't checked out Thugger Daily, I'm going to drop a link in the chat for y'all so you can go check out Thugger Daily. Let me scroll back through here and find these. Let me see. Yeah, here we go. So this is the part we reviewed on, what was it, yesterday? It's Thugger Daily says Young Thug's lawyer Brian Steele says he doesn't talk to anyone on the prosecution team except for Fannie Willis. Now, he is not feeling the prosecutor right now.
Never taking Miss Love's proffer. Okay, so she says that I said, I don't talk with Miss Love, by the way, if you didn't know that. So I never said anything to her. But that I said.
Is there somebody on the state's case that you are able to talk to?
Yeah, Miss Willis.
All right. Well, okay.
Yeah, and if that's your last option, I mean, it's gonna be pretty much out of luck. Shout out to Thugger Daily. This one, he says, oh, this was a good moment here too. So Thugger Daily said, "Don't mind me, just documenting clips of the new judge making Miss Love look stupid." So many instances.
Georgia app 423, which is Phillips versus the state. And
when is that from?
I'm sorry.
What year?
Just 1 second, Your Honor. That's a 78 case.
Okay, so that one's not relevant at all.
Old case.
Because we have a new evidence code since 78. So, okay.
And Your Honor, even with Georgia app.
She said, so that's not relevant at all.
Phillips versus the state. And
when is that from?
All right, we got this one. Let's rewind it.
In a written or oral filing.
Okay. All right, well.
In a written or oral filing.
Okay. All right, well. I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Love.
I remember that moment too. We saw this one.
Okay, so.
She is not feeling it at all. We got another one here. Oh, this was a good moment too. So let's go all the way back. This was a good moment here too. Thugger Daily says, Miss Hilton has a scheduling issue next week, so they asked the judge to do a different witness first. What? So many of y'all remember when Melnick, Lil Woody's lawyer, asked for the exact same thing. Excuse me. With the exact same witness, and the state/judge said, tough luck. Yeah, you gotta keep it moving. It's clear that this case is gonna keep moving no matter what anybody has going on. Plus, if we remember during the update, Judge Whitaker asked everyone, hey, do y'all have anything coming up? Are we gonna be good? We don't need to put anything on hold. And now all of a sudden this happens.
There is a request for the court to consider.
Come on, man.
Having a witness who is not Mr. Copeland be the next witness because of a scheduling matter for the attorney who was examining Mr. Copeland.
Makes no sense.
Now, we have to redo at least part of Mr. Copeland's testimony anyway. I don't know if that's an issue to y'all. We're going to have to come up with whatever we're going to say with regard to, you may be hearing a lot of this again, and you're going to need to disregard what you heard before. We'll have to work on that, and y'all be thinking about that. That's y'all's homework.
That's a lot of testimony to disregard.
Is there objection to moving to another witness and coming back to Mr. Copeland? And if so, what is it? And then I'll consider whether I'm going to permit it or not. There is a request for the court to.
Yeah, that's lame, man. I don't know why they would do that. Shout out to Steve is here. He says, no, they on break. Yeah, they're on break. We probably got about 10 minutes. Let me see. I'm going to double check back in here and see if we're back yet. Nope. We're not back yet. So we'll check back in a second. We're just reviewing some of these highlights that Thugger Daily's got out here. And there was one more motion that I wanted to look at too, but tap the information, vague questions. Okay, I remember these. I got them now. All right, here we go. So this one, Thugger Daily says, Bruce Harvey continues to object to the notion that the jury can simply disregard Woody's testimony. I agree. 100%. Thug's lawyer objects to doing a different witness list. So the judge says Little Woody is the next witness and just may let someone other than Hilton take over. Thank God, because Little Woody was cooking her.
Mr. Copeland and having to do it all over again. It's impossible. There's no way in the world.
All right, well,
The jury
yeah.
just disregard Mr. Copeland.
He's right.
Okay, but that's not what I was asking. I understand that you just think that is a total disaster and makes this trial one that needs to be a mistrial. I understand, but
It is.
aside, just with regard to scheduling,
Look at Max
assuming we
laughing.
are going to go forward for the purposes of this discussion, and assuming that, I mean, y'all don't stipulate to everything he's already said and that we have to redo a part of his testimony. Well, whether we do or not, we're going to have to continue his testimony. So is there an objection to essentially taking some other witness out of order in the midst of his testimony?
Yes, that doesn't make
Your Honor,
sense.
Yes.
I
Keith
object.
Adams on behalf of Mr. Williams. Mr. Steele and I have consulted about that. And I don't purport to speak for anyone else. We do object
Okay.
to that. We believe that given the
That's a
complexity
nice suit.
of Mr. Copeland's testimony and the issues surrounding his testimony and the confusion that will probably already attach to a jury coming in and seeing some of what Mr. Copeland's heard and testified to and possibly having to be instructed about disregarding some of his testimony, we would object to going to another witness.
All right. I appreciate it. And I think with that objection, it's well-founded. So y'all do what you have to do with regard to who might be handling the examination, but we will
I agree.
pick back up with Mr. Copeland and finish with him before we move to another witness.
Would you allow another member from the state to continue his examination?
Oh, I know the gynecologist in here. Is that Dr. EJ up in here? Amy, man. Shout out to Amy. Salute to Dr. EJ out there doing some great work here in Fulton County. That is amazing. Thank you for stopping by, Dr. EJ. I know Amy's out here sharing the love too. Appreciate you stopping by. We're not gonna put you to blast, but Amy's over there. we got the OBGYNs in the building. Y'all give it up to Dr. EJ out here. Look at Amy networking, man. I love it. All right, here's another one. This was a good one too. What does Thugger Daily say? The stream has been cutting. It says the stream has been coming off. My bad. What did he say? Okay, this was Max Schardt. We got to see this morning, but for those of y'all who missed it, this is Max Schardt. He was pissed about what we read in that transcript from the June 7th ex parte meeting. And Thugger Daily has another clip for us for what happened here. Max Schardt said, "The steam has been coming off my bald head all night." Listen to this.
This is disgusting.
He was pissed.
But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning. And this is absolutely gross and disgusting. And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken and it's not okay.
He's right, man. Give it up for Max. This is the first time, well, not the first time, but this is one of the main times we see Max pop off. He was heated about everything that's going on in this trial. He's absolutely 1000% correct. I don't even know how the defense can look at the prosecution at this point, right? Because they've been talking so much stuff behind the scenes to Judge Glanville, to Lil Woody, and so much is wrong about this. I know Judge Whitaker, she's going to take that into account when she's looking at all the facts behind these motions for mistrial, specifically the one that we mentioned today that was filed by Doug Weinstein. And I can guarantee y'all, either the end of the day today or tomorrow, Brian Steele is going to do his thing and he'll file another motion or an updated motion. Maybe we'll see a supplement to motion for mistrial, because y'all know he likes to do that too. Crazy up in here. Let me play the rest of this clip.
It's not okay.
And we'll check and see if
It's
we're back
offensive. And it's not your fault, Judge. You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
As you should be.
My head skin's been coming off my bald head all night. Nothing about this is okay. Yes.
Oh, man. Yeah, and he's 1000% correct. Hopefully y'all can't hear all this noise. They're outside my window chopping down this crepe myrtle tree. And it is loud. They are going wild out there. Shout out to them though, handling business. And we got another one, Doug Weinstein. We see him in rare form. We read his motion for mistrial, or an updated motion for mistrial that he sent this morning, hot off the press. And yeah, he was not happy about everything that went down too.
What I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot. What I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot. What I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying.
And again, even going back to what I was saying about Kayla was up here saying, hey, you know, I don't want to talk bad about Love and Hilton. I've got to work with them. I have some clients that I might be working with. And they were up here taking shots at her. No loyalty, man. Y'all is, this is wild. Goner Dang says, YSL Brian Steele flying off the top rope with more emotions soon. You already know. You already know exactly what's about to happen. Brian Steele is going to drop the hammer ASAP. We've got Steve Go Shoot. That's a dope name, man. Shout out to Steve Go Shoot. He says 100% correct. Does not matter. No jury in the world is going to convict him, period. Not after this. Not after this. Nope. And I mean, as we mentioned, y'all could go out in the grocery store here. I'm here in Fulton County. Y'all could go to the grocery store, ask anybody about YSL or Young Thug. They're going to know exactly what you're talking about. They're going to know exactly what you're talking about. I've had people in real life tell me, hey, yeah, I've seen, you look familiar. You make content or something. I'm like, nope. You haven't been covering that YSL trial? Yeah, that's me. And my channel's not even that big. Everybody in this area is watching and covering this. We got Dr. EJ up in here. Says, perhaps if we're getting checked, people wouldn't be telling them to get back. Uh-oh. Shout out to Dr. EJ. Marble Snapaholic is in here as well. It's crazy. All right, it is right about 11 o'clock. So let me see if we are back in court yet. We know Judge Whitaker likes to be punctual, so hopefully she'll get back in here soon. What else are y'all thinking though? Drop some more comments in there. We've got over 600,000 of y'all in here, 400 likes. Thank y'all for liking the video too. If y'all could just take a second and like the video. Not only is it free, not only does it help the show and the channel continue to grow, but it lets the algorithm know that you guys are enjoying the show and it shares it with more people. So if y'all could please like the video, I beg for likes like crazy. And I'm not ashamed of it either. Mar says everyone in Atlanta talks about it. It's free YSL wherever you go. That's a fact. Marvel says their attitude has a stench.
Hey, yo, what did he say?
Oh man. Okay, here come the OBGYN jokes. No gynecologist jokes in the chat. Shout out to Dr. EJ, man. And shout out to Amy for sharing the stream with people in real life. That's love right there. I appreciate it. Mar says blunt break. Yep. He also said love is not 100% wrong. I mean, again, you know, big shout out to Kayla. She is not 100% wrong. It is a little strange that the prosecution's key witness is being represented by someone who has a relationship with the defendant. What? This whole thing was messy. Super messy. Let me see. I think they might be back. Let's go for, oh, here we go. We're back. We back. Let's get it. Oh, I need to like the video over here by Law and Crime. My bad, y'all. We're back, y'all.
Case law about your direct question regarding the prior inconsistent statement and whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? And Your Honor, I have.
Here we go.
Three cases for the court.
Okay.
I have Green v. State. I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Schardt v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS, v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes, thank you.
Hey, what's up, Smokey?
I'll give it to you. Give me 1 second.
Thank you.
I gave you green already, Mr. Weinstein. I gave you green already. Which one did I give you?
Mr. Matthews. Thank you.
You're welcome.
Thank you very much.
You're welcome.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the only one I've looked at so far, is there one that says, if you say, yeah, that was a total lie?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor, it says during the course of their investigation, officer interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone.
What did she
The
say?
state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, "I be getting high, I don't know." After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said, a witness's failure to remember making a
So hang on, you're talking too fast for the court reporter to take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor, Division 3.
Okay.
And when the court, the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia, 63 at 66, pages 66 through 67. They further cite Bridgewater, which is 309 Georgia, at Penn site 887. Which cited defendants' denied recollection of making a statement provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Schardt that discusses primarily that the state does not now have to go through every single inconsistency.
Okay.
But that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement.
So all you have to do is deny it?
Going into further details, that's kind of our summation of Schardt.
All right.
And then Odom, Your Honor,
that must
is
be nice.
a federal case on the same point as the Green case, Your Honor.
Thank you. Appreciate it. Counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Max Schardt or someone. But I just want to state that the foundational element for this argument doesn't even exist, because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't, because we...
Right. No, I mean, I don't think anybody disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true, yes, he may get up there, who knows what he's going to say. But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this, and so let's figure out what the...
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely. Okay.
Boy, things are getting testy today.
Remember that there were at least 2 full days of testimony from the 10th to the 12th, and it's the state's remembrance that the I lied started early in his testimony. So, but we can.
What about the I did these crimes?
And with regard to that, the court reporter has said that she probably, what did she say, Ms. Firstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said by either late today or tomorrow morning, she should have, I believe it's June 10th. June 11th, and then would be working on June 12th, shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and All of the 12.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked 3 questions in that.
All right. So do we already have the 10th somewhere? We'll figure that out. But anyway,
yeah, we got
should
it.
all be
We definitely
forthcoming
got it.
soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement, quote, lies to try to get out of trouble, unquote, and that he would, quote, say anything, unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe. I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said 23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or testimony by contradiction. So I found this case, if you don't mind pulling up, or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. And that is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pre-trial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's I don't want to mislead the court, it's under the former 24-9-83.
Just cross-examine Woody already.
Then I looked at Cummings, which is cited, which is Cummings versus State, which is 280 Georgia. 831, it's in Division 3. It's a 2000, now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division.
Come on, Brian, get it together.
3.
Yeah, so it looks like in that case, he just refuses to answer whatsoever.
Exactly, which is really, obviously, saying I don't remember, I don't recall, I don't, I may have
That's
said
what they told him
something.
to do.
Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson, I thought right on point and bad for my position, but we just tell the truth. So I want to arm you with it. But then we always look back. We're always taught to look back on the cases cited. And that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So
that's your point.
I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green, Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Yes.
All right. Thank you, Ms. Hilton. That was a helpful use of our break.
Yeah, thank goodness, finally.
So, with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the state as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that
a lot of the audio was just bad on that one.
It was what was hashed out during
the state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done. 3 of them were definitely done after the recusal motion was filed.
Okay. Well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the other, I know we were in the middle of playing 2 of them during that time period. I just need to
you couldn't really hear anything though.
When we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make come to agreement on.
And we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So,
all right, I'm not sure I follow you.
Okay.
So, what you say you want to revisit? So
I'm not sure what she's asking either.
I think first it would be helpful to know which ones were hashed out before the recusal motion, and then we can just say that's what we're going with because that was prior to any issue, and therefore we can stay with that. As for anything that was post-recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So let's.
They don't want to do it.
Have y'all had discussions yet about, or I mean, I thought y'all wanted to figure out what was actually done and what wasn't.
Brian still said he
And I
doesn't
guess
want to
maybe
talk to
I
him.
misinterpreted what the court, I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection.
Max Schardt does.
To the current state of the redactions based upon what occurred.
All right.
And so that's what I thought I understood.
Okay, and that was January 11th, January 28th.
February 20th and February 21st.
And so you will let me know which one or ones of those were hashed out before. And that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided. And if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody yet. Is that true?
No, we did hash out that one as well.
Oh, you
want
to revisit that one?
Yes, Your Honor.
Okay. Okay. All right, can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the
Oh, we know Max is going to say
evidentiary
something.
determinations made as
Come on,
to
Max.
any of those?
Where's Max at? Is that him? Oh, called it.
Respectfully. And I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post-serving the recusal motion at this time.
Okay.
So
well,
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th.
Yes.
Okay. Which
a lot.
is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that.
Yeah, it's a lot of work, man.
Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations where we agreed and didn't agree at the time.
Okay.
So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
I'm sorry I don't have a better answer for you.
Okay.
She said, sit down, Max. Come on.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Schardt just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Schardt is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Uh-oh. She's about to get him.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this, because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So.
Seems like it was.
Okay. All right, so how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary. Sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over. Well, we have turned over the statements that Mr. Zachary has made.
All right.
To the police that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what he's going to do.
Okay, so for a whole lot of this, I mean, y'all can't really, let's assume.
Blame it on Glanville.
He testifies, let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling, but if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And with the court, is the court asking?
As a taxpayer, I appreciate that.
We can't provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7, lines whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then, of course, if in court I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I, of course, will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes,
yeah, get those timestamps ready.
That would be ideal. Okay, so is anybody ready to go on Mr. Zachary?
Oh, we might have a new witness, y'all.
Anybody? Does everybody have Mr. Zachary's statements?
Yes.
Okay.
That's fine. All right, I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take it. So
shout out to Max.
There are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy
But y'all are all old like me and you like paper.
And because we have our notes on the paper too. And so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today.
Yeah.
So I didn't bring the transcripts with all my notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but
Understood.
okay. Yeah, I hear you. You're not
Yeah,
ready,
why'd
but
you give
can
in,
be
man?
ready
Bring
soon.
little Woody back.
So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least two, I believe maybe three statements.
Thank y'all for the likes.
And
We got
I'm
400
estimating
likes.
here, I
Thank
would
y'all.
say a total of about 9 hours of
Okay.
talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and other witnesses that you're going to be getting to soon?
We have been, not entirely winnowed, as the court said, down. We have identified jail calls of particular, not
get that mic
witnesses,
together.
but defendants that we intended to use. And when the court says particular witnesses,
I mean, Mr. Zachary is a witness, right?
but I don't believe that we have any jail calls from Quindary Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use, and then they can say, only look at those. Here are the objections we have.
Yes, I can do that. I have not broken it apart by segment scientific use, as I wasn't yet
at him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that
no, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if not,
yeah, she's telling them to get ready.
Of course, time, but if during,
I'm open to suggestions since what I've come up with so far isn't working.
what I can do, what we can do as a prosecution team over the next however amount of time the court wishes to allow us is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify just to the court. And
30 more witnesses still.
And begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some of them.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that.
No pressure.
Yes.
Yes.
I said it, so
You did say it.
You know, there we go. But I might overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay, so anyone?
We got to get it together, man. Let's keep it moving.
Anything right now?
Ready for a mistrial.
It's not anything. It's not anything we can go forward with, but Judge Glanville had given me, on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit during the course of the trial.
Okay.
That notice was filed on or about, by the state, on or about, excuse me, November 3rd.
Okay.
A long time
last
ago.
year, obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same, they only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay. Understood.
So I want to get that on the record. And finally, you know, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever
Right.
that I want to reallege and reaffirm.
And Mr. Nichols is charged with count one, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take under consideration.
Mistrial.
Sure.
And I'll do that for, I know that all 6 of the defendants here are charged in count one, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide
Sounds like
you
they
with
wanted
that.
to get
Whether you
everyone on
ultimately
that.
do that or not.
Yeah,
this is
I don't
what
know.
we've been
I'll hear from
arguing.
both sides. But
Yeah, it's what we've been arguing about the whole time, and what I've preserved going forward.
Sure.
All right, so we'll get you that
Okay.
as soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. What does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay.
Yes.
And then you're saying there's another one?
Yes, that's
Oh,
November.
Lord.
That was filed on November 30th of 2022.
Okay. And give me a second, Laura.
So we got a little bit of a break here real quick. What are y'all thinking, man? Let me know what y'all are feeling and thinking in the chat. Shout out to Fatu in the building. He said Miss Wheezy Jefferson.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang at trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial, or in the presence of a defendant currently on trial, that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice?
It'll be Max or Harvey that's going to speak up.
Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them it's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide.
Sorry, when you say in this particular notice, which notice?
The November 6, 2023 notice.
Okay. November 6th. November 3rd?
He said it wrong.
It's filed.
November, okay. You provided notice of 3 different statements.
Right. 3 specific ones.
Okay.
Yes.
Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are. Just one moment.
All right.
No, defense is not going to go for that. They're not going to go for that. I was saying it's blurry. See if I can go up to 480.
And so that we are
Should
clear
be
that
better.
there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the...
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can send it to the court.
There are a lot of filings
We can
in
send
this
it to the
case,
court.
but Ms. Persifield has saved it for me somewhere, but there are already a lot of things in our file also. So.
We'll send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it? Is emailing it to me.
Just trying to
because
figure
I
something
need
out.
Lots of assistance. Thank you, Laura.
What do y'all think so far, man? Let me know. Let's update this title.
And so was there an order at some point or a direction from the judge to tell the defense which statements she believed to be co-conspirator statements that led to this supplement?
Yes.
Yes. Okay.
I'm looking for.
Okay. I mean, if there was, that's all I need to know. So yes. So, okay. Now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
Uh-oh.
They are included as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement, we intend to use it.
Yes.
Okay, well, sure.
Uh-oh.
Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There
I
are
knew Max was going to say
thousands
something.
of jail calls involving
8,000 to
dozens
be
of
exact.
people.
Yeah.
Too
There
many.
are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery. Here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether
they keep trying to hold up this case
in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
That's crazy.
1 second, I'm
okay. She said, give me 1
second. Yeah, she's not playing around.
But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
Oh, man. Mr. Tesla, alumnus, a graduate, or former student of a particular school, college, or university.
And
yes,
so that the court knows what I'm doing, I overheated. And so I had to wait.
By which you mean your laptop overheated?
I do mean my laptop. And I was
because I've told y'all not to overheat anymore.
So that's what's
okay
happening.
That is hilarious. Judge Whitaker is on it, man. You got to give her that.
Yes, sir.
While she's waiting for that,
sure.
Could I just briefly address a side issue?
Sure.
When we met for the status conference,
yes.
I believe Mr. Harvey asked you if you would support us when other judges try to drag us in.
I recall that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, oh, I'd like Mr. Harvey for trial. And I said, no, you can't have him. So
thank you so much,
yeah.
Your Honor.
Mm-hmm.
But one thing that wasn't clear, or maybe I misunderstood it. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that. Mm-hmm. So you were referencing that week last week where we were out and why we weren't working to prepare for this.
Right.
I was being called into court all over the state of Georgia, just because, and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial.
Yeah, they're working these guys,
because
man.
We did have a lot of preparation to do for this week, but unfortunately, I was hauled over all over the state.
Right, and we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we can work on this trial during those breaks?
Because, we may just have to decide that on a break-by-break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial. where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or
We got a
take
lot going
Friday
on.
mornings for motions and Friday afternoons off or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for, just for myself.
I mean, let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer right now.
Thank you.
Yeah, we saw Brian Steele was actually covering he was on another trial as well while they were on break. So these guys are working, man. So we're waiting on the state, I guess.
How long are you going to need?
She said a minute.
2 minutes, 10 minutes, 1 minute. Okay.
Still waiting on the state. What do y'all think so far? We got everybody laughing in the chat. Dang's laughing. Amy's laughing. We got EM is in the building. Shout out to EM. Thank you for stopping by. Says this judge is about her business. That is an understatement. And Iris is in here too, the new timer. Appreciate you stopping by. Says, forgive my lack of legal knowledge, but if a judge anticipates that a case might be overturned on appeal, will the judge still proceed with the case? Unless she just says it now, she has to do her job and follow the process. Kind of like what we talked about
Your Honor,
with
we're going to
the Supreme Court trying to
allow Mr. Atkins to stand up and give to the court the cause that we have
Rule on Judge Glanville.
identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
He might be, Dang.
The wiretaps.
One of the wiretaps.
He might be.
And Your Honor, this wiretap is it's a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of I wanted for the defense to know where this specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties to speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
Ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay. So
Sheesh, that's a
instead
lot.
of standing there and reading them all, do you have them in writing?
I do. With what I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document that has the date, time, reference number.
I would think that would be
PDF
easier
page.
for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with is Demekion Garlington, who is a severed co-defendant.
Right. Okay.
And
nobody's going to read that.
I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay.
For this particular portion.
Okay. All right. So there are going to be a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator, you, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct, of Mr. Sumlin,
And
who is also, he has pled guilty, but he was one of the 28 indicted defendants in this.
So you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor. Yes, Your Honor.
All right, Sumlin. And
I wonder if they're going to bring up Gunna too.
You can do the same for him.
Correct.
Okay, perfect.
And he has less, it's hard for me to ballpark the number.
That's fine. I just was like, if it's, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay. All right. So that is two further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor.
Yeah, nobody's reading
We
it.
have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay.
That's a part of the 5, excuse me,
Jail calls.
about a portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in?
Somebody say something.
Okay, that was part of the notice, so that one's good.
I don't think it was part of the notice, but
they don't think that was part of the notice, but they're willing for y'all to say that's good.
But there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and all right, but y'all have already been litigating that, so I'm going to call that one good in terms of notice. Whom else?
That's crazy about that other ex parte meeting too.
All right. Questions.
Together, yeah.
I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay.
Yes.
Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right.
All right, what else we got, y'all?
Can you provide to this judge whatever that supplement was so that I know? Thank you. Do y'all, deputies, you know whether lunch is here yet for the, okay, why don't we break for lunch?
Oh man, we're
Be
breaking
back
for lunch.
at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
This is a quick question.
Yep.
I can't. I'm having a hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay.
I'll look for that. I'll look for
All right,
that.
lunch sounds good. I'm not gonna lie.
I referenced where it said that you can't use.
What's up, Kat?
That'll be great.
Good to see you.
Thank you. All right, we're in recess. Let's say till 1:20 since we've already eaten up like 5 minutes.
Pun intended, right? Okay, there it is, y'all. We taking a break. Y'all know I done ran out of gas. Oh man, what do y'all think? This is crazy.
All of them, when the court had asked me earlier, whether in all of the jail calls, all of the
we might not be done.
wiretaps, all of the recordings.
Yes, at this stage of the game, we need to give notice to the defense of every potential co-conspirator statement. And if in the afternoon you can do essentially what Mr. Atkins just did, it's going to be this set of statements.
We're not done yet.
You know, and we'll give you the details of where to find it later. That's fine. But yeah, it's going to be this witness, that witness, and the other witness in these statements as to each of them. Yes, because A, they need to know at this point, and B, we need to know what we need to litigate at this point. Okay. So yes, thank you. All right, in recess.
All right, y'all. We are in recess. I'm hungry, man. I gotta get some lunch too. That is it, man. Day 2 of the trial. It's officially underway. Now, I want to know what y'all think. Let me see if anybody called in. This has been crazy. What do y'all think is going to happen with that whole ex parte meeting that they just talked about? I mean, they took some major shots. Took shots at Mr. Melnick, who has been subpoenaed apparently, so he'll be in court at some point. They took shots at Kayla. I mean, they were talking nasty about Mr. Weinstein, Max Schardt, Brian Steele. I mean, they were going at everybody. It is crazy. Lucy asked a great question. Can Woody come in and plead the fifth again? Yeah, he can. He definitely can, but guess where he's going to go? Right back to jail. Because yep, that right is gone. Kat asked the same question. If Woody comes back, can he try and plead the fifth again? He can. He can try, but he's going to get thrown in jail. He's not allowed to. He gave up that right when he took the immunity. Now he has to testify or go in jail. Those are your two options. Lauren said, she's killing me with the breaks. Yeah. Mr. Tesla said he's got honey hot wings and chips for lunch. Oh, mama. That's what I'm talking about. All right. We didn't have anybody call in, so I guess we will go ahead and break until tomorrow morning. Y'all know we're going to do it again tomorrow morning. I don't know if we're going to cover the trial tomorrow morning, but these proceedings have been so eventful. I feel like I would be remiss if I didn't cover it. So let me know what y'all think. Should we cover it tomorrow? I think we probably will. Oh, Lauren says she's having tacos. Her company caters. Shout out to everybody getting fed by their companies, man. Iris says, could Woody be watching all of this? I'm sure he is. Lauren Robinson says, see you over at Kat's. Okay, you're going over to Kat, not Williams live stream. That's dope. Kat also says, how is there still a trial at all? Beats me. But it looks like what's going to happen is Judge Whitaker, she's not just going to jump to conclusions. She's going to review everything. She's going to do her due diligence, and then she's going to make her decision from there. She already mentioned today we will get, and you guys being the defense will have an opportunity to request a mistrial, and we'll get to that point. But she said, that's not right now. We need to go through the process. I need to make sure we have everything in order, make sure we have all the testimony and the witnesses and the evidence set up and ready to go. Then we'll get to that point at a later date. So we'll see what happens. We're going to go ahead and get up out of here. Y'all enjoy your tacos and your hot wings and all that good stuff. We will be back tomorrow at 8:45 on the dot a.m. Eastern Standard Time. If anything goes down later on this afternoon with the trial, we will be covering it with some of the videos that we drop here on the ClassE Beats YouTube channel. Make sure if y'all haven't yet subscribed, hit the notification bell so you don't miss any time I drop a new video. We're dropping 3 videos a day now, y'all. There's just too much going on. 3 videos a day. So if y'all want to stay up to date, make sure you subscribe. And if you could, hit the like button on your way out. It's free and it helps the show continue to grow. All right. I will see some of y'all tonight over on the Song of the Night Live. We've got a versus challenge for all the artists who are going to be over there. And I hope y'all have a great rest of your day. You know what to do. Keep growing, keep pushing, keep it classy. You know, peace. Shout out to Amy up in here sharing the stream with their doctor. JC is in here. Still don't see any real evidence whatsoever. Yeah, we'll get there one day. We'll get there.
I mean, most of basic get replaced quick. I'll never sacrifice my soul. Truth is, so I might never get 1 million records sold. But that's cool, cause I'm good with the creator. He nurtured my thoughts, so I present you with verbal flavor. You never listen to what no haters say. We pray for them, but we gon' move it this way. We moving forward, y'all.